From the News Channel 5 Network, this is MorningLine.
Good morning, everyone. Thanks for joining us on MorningLine. Nick Beres here. We've got a good show on tap for you on this Wednesday. We've been talking all along, and we followed. It's made headlines since it happened and continues to, leading up to next Monday, where we anticipate the beginning of the Vanderbilt Rape Trial. Okay, the Vanderbilt Rape case scheduled to go to trial on Monday. There's some things that could delay that. We're going to get into that this morning. But it seems like every day there's another motion being filed, some kind of hearing being held, and I'll tell you, it gets confusing, it's technical, and frankly, it gets a little tedious, but welcome to the legal process. This is what happens, especially in these high-profile cases. To help sift through this and answer it this morning, we're going to take your phone calls, and our guest this morning is someone very open about things. It's rare that you get an attorney just days before such a case like this willing to come on and talk about it when he's directly involved, but that's what Fletcher Long is known for. He doesn't hide, he answers questions, and he's here with us this morning. Fletcher, it's good to have you.
Good morning.
It's a pleasure. Fletcher Long, one of the attorneys, lead attorney, I dare say, along with three or others more that are involved with Brandon Vandenberg, one of two of the suspects that are scheduled to go to trial on Monday. Do you think it's going to happen Monday?
Well, I don't know. I think as a defense team, we have to be ready to go Monday. We have filed some motions that could delay the beginning of the trial, but it's not really my call as to whether they will or won't. So it's our job to be prepared regardless.
All right, let's lay it out real quickly. For those of you who don't perhaps know, this case, his client and Corey Beatty are two individuals that are charged with rape, involved with an alleged assault on a female student on a Vanderbilt campus last year. They both, and there you see Brandon Vandenberg, taking the stand during a prior motions hearing. He was a highly sought-after tight end football recruit involved in this now. Fletcher representing him, along with, as I said, some other lawyers on this team. Now, the issue at hand today, there's going to be a hearing at 1 o'clock today before Judge Monty Watkins. I think he's going to be ruling on whether the admissibility of some photographs and things like this. But late last week, you and John Herbison and the rest of the legal team filed a motion asking the judge to recuse himself a week before trial, asking him to step away and say, no, I should not preside over this trial. Why, and what happens now?
Well, I'm unclear as to whether I can talk about what we have filed or hadn't filed, because a lot of these things have been filed under seal, and I'm not really sure as to whether this is one or not. So because of that existing court order, I don't feel like I'm really at liberty to discuss what we have filed. All I can really say is that it's our job, and I don't know from where you got your information either, because I can tell you that it wasn't from me. But you know, that's why you're the #1 investigative journalist in the Nashville area, I suppose. But I can tell you that we have an obligation to our client to file any motion or any press any position which would further his defense interest. And in our mind, if it is something that should be pressed in order to preserve the record in the event of appeal, it's something that we're going to have to do.
Okay, now I know we've seen in open court that the defense has had issues with a lot of the rulings by the judge, which seems to have gone the way of the prosecution, specifically the fact that the alleged victim in this case was allowed to watch one of the hearings on closed-circuit TV in the DA's office without your knowledge. And that's been talked about in open court. That's not under seal, and we've heard orders from the judge saying that, you know, there's nothing wrong with that.
I think anything discussed in open court is fair game.
Yeah, so
I think that's fair game.
If you would then, what is the big issue here? You feel there was ex parte communications, meaning just between the judge and the prosecution, leaving you guys out of it, and you're upset about that?
Well, the real issue, and I'm going to talk in general terms, generally when a lawyer requests witnesses to be sequestered, it's so that the witness cannot coach themselves on how to answer questions based on the fact that they're given the questions ahead of time.
Right.
That is why you want them sequestered. You don't want witnesses collaborating with each other and arriving at stories that were manufactured in the hallway. You don't want a witness watching proceedings and enabling themselves to better answer questions that you were going to ask of them because they've had an opportunity to manufacture a response. And so the issue is that we had asked for the witnesses to be sequestered, and a witness was able to watch via video stream proceedings that even had she been in the courtroom, she would not have been party to, because they would have been taken up outside of her presence, sidebars and things of that nature.
Had you known that she was watching, you would not have presented perhaps what you did.
Oh, I wouldn't have argued some of the things that were argued and laid out what the intended testimony might be or the areas in which we wish to inquire quite as elaborately and simply as I did, because I would have known that the person that was going to be subjected to the examination is watching. I did not know this. And because I did not know this, it enabled someone to have the opportunity. I don't know what she did or didn't do, but it enabled someone to have the opportunity to manufacture a response tailored to areas in which she knew I was to inquire. So,
is there any difference, though? I understand you keep saying witness, and yes, I understand she could be a witness. You've subpoenaed her, but she's also the alleged victim here. Does that change anything? I mean, the judge was saying in court she has the absolute right as the alleged victim here.
But she wasn't in the courtroom. She had the right to be present for proceedings, but she wasn't.
Where you would have been able to see her.
The issue's not whether she could have been in the courtroom. The issue was that we thought she was sequestered and thought we were at liberty to lay out theories, and we really weren't. And that's something, as Mr. Vandenberg's attorneys, we should have known. Okay. We should have had an opportunity to be more clandestine in our arguments in an attempt to preserve the credibility of information that she related from the witness stand or not from the witness stand in cloister or whatever. We should have had an opportunity to know that she was watching the argument, and we didn't, and it changed what our strategy would have been, and that's inappropriate, we feel. I'm not going to comment on whether it's inappropriate because, you know, the court's ruling may be different than my own personal feelings.
Yeah.
But I'm telling you as a pretty seasoned trial attorney that it would have impacted the arguments that I made had I known that they were being viewed by someone that I was going to examine.
Okay, so that's why I was going to ask you, as a seasoned trial attorney who's been involved in more than his share of high-profile cases, what do you think's going on here with the judge then? I mean, he believes this. Judge Monty Watkins, to my experience with him, is a fine judge and thoughtful and goes through this. Do you think there is a blatant bias for the prosecution? Is that what you think? Is he just making the wrong calls in your mind? What do you think? Because, I mean, by most accounts, he is a very good judge.
Let me just say this. I am very fond of Judge Watkins. I knew Judge Watkins when he did for a living what I do for a living. Judge Watkins and I battled the government side by side in cases. We had co-defendants together. He took over a case from me one time and did a very good job trying a case that I began. You know, I'm very fond of him. I have no idea. You know, he is a fine man, and I think that he's someone that I think you should be proud that someone like that has been elected judge in Davidson County. He is a fine man, and I hold him in the highest personal regard. That being said, I have an obligation to defend my client. I don't agree with his rulings. I don't know everything. You know, I mean, I think that his rulings are legally fallible. And so, and if I am of that opinion, then I have to take the next step in that process. And I know Monty is professional, pardon me, Judge Watkins. I know that he is a professional, as am I, and neither one of us are going to take it personally. We each have a job to do.
Yeah.
And, you know, if I think he's doing a poor job, I'm entitled to that opinion. And if I think he's doing a poor job on behalf of a defendant that I am defending, then I have an obligation to challenge the ruling, and that is what we're merely attempting to do. So it's not something that anybody should interpret. I can promise you this. Judge Watkins doesn't care who wins this trial. I mean, if you're on this jury and you become of the opinion that he's for either side, he's really not. He's impartial. He doesn't care. So you really can't glean from his rulings that he's for one side or the other because he's not for either side.
Right.
But, you know, judges sometimes make rulings that are fallible and that you can challenge, and that's why we have courts of appeal.
Gotcha.
We wouldn't have courts of appeal without it. So
right. And that's exactly what you're doing.
And we have an obligation to do it, and we intend to. So,
can we talk a little bit about the decision that was made? I know that the other defendant here, Corey Beatty, his attorney had requested to have the cases severed. The judge denied that. They're going to be tried together. I had talked with you on more than one occasion. You said, in your mind, it doesn't really matter to you, does it?
No, it really doesn't. I think that every defendant, when you have multiple defendants, has the legal entitlement for their own actions to be judged independently of the other defendants. And I think that this jury can do that. And, you know, I understand why Mr. Beatty might not want to go to trial with Mr. Vandenberg. I have an opinion as to the relative culpability of the two defendants. And in my opinion, I will press to a jury when that time comes. I can understand that, but I mean, the judge didn't see it the way that Mr. Warwick saw it. I was fine with either decision.
As we go to the break, do you think it's possible that one could be found guilty and the other innocent?
I think
or will they be a package deal?
I think that may even be very probable. But
okay.
I mean, I don't know. I'm going to tell you that Mr. Beatty has an excellent attorney. And not just Warwick. This Liz Powers is strong.
Okay.
And he's got excellent representation. There are defenses that he can mount and assert that he will. And it'll be up for the jury to decide. It's like I said, don't ever think that any trial ever comes off the witness stand the same way it looks sitting in a file.
All right, on that note, we got to take a break. When we come back, we'll open up the phone line, 737-7587. You can sit back and listen. Fletcher can talk and tell us and get into some of these details that are fascinating, or we can answer some of your questions. If you want to jump in now, we'll open up the lines. We'll talk more. Talk a little bit, too, about you, how you prepare, if you prepare differently, which I suspect you don't, for these very high-profile cases and many of these other cases that you handle that a lot of people don't hear about. But, you know, profile cameras in the courtroom can make a difference. We'll be back with more right after this.